Hi, everybody. I'm Professor Tarhan, and I'm going to speak to you for a few minutes today about interviewing in the legal setting, the legal environment, litigation situations. Interviewing is a part of a lot of other things that legal professionals, paralegals, attorneys, legal assistants will complete in the usually in the litigation process or something to do with a legal matter. And there's more than just interviewing. There's a lot of other activities, including investigation techniques, aside from what professional investigators will do. But also, legal professionals will use, sometimes they'll use forensic tools and have access to other activities. But interviewing in and of itself is I should say, a learned skill. But interviewing is a very important part of what the paralegal, legal assistant, legal professional needs to have a good skill set handle on. So there are some priorities and concerns I wanted to speak about for a few minutes. First and foremost, no matter what you're doing as a legal professional, you have to keep in mind your ethical duties, which color and concern everything. You have to be concerned about your candor in your communications and your honesty with the interviewees. You don't want to use trickery. You also have to be concerned about all the ethical canons that apply to the profession in terms of confidentiality and attorney-client privilege. And, you can't reveal things to the interviewee in the hopes of getting some information back. You have to avoid dishonesty and things that would involve questionable integrity, things like coercion, manipulation, or leading your vulnerable witnesses. Because if you commit these acts, then later on the substance of the interview is tainted, and it may end up being a futile interview because you can't end up using it in the legal proceeding if the other side discovers these, untoward tactics and files motions to suppress things and so forth. So you always have to remain ethical, above board, and comply with all the other ethical duties when you're pursuing an interview of whatever kind or type it is. You have to understand the boundaries, the legal boundaries, the ethical boundaries when you're interviewing represented parties, okay? In terms of your professional responsibilities, you have to distinguish fact gathering from legal advice. Paralegals can't give legal advice. No one but attorneys can give actual advice. Sometimes that can be a gray area, whether or not what you're doing is providing facts to an interviewee to get more information from them, or maybe it tips over into giving legal advice. So these are all concerns that you will study in ethics coursework. Okay. But you have to also avoid your conflicts of interest, maintain your neutrality when interviewing adverse witnesses. You have to use, I think above all else here, what I'm saying is, in addition to your ethical duties and your professional responsibilities, your interpersonal skills will make a big difference if you're trying to get an effective interview. And those are enhanced. Some of this, you have to learn it. There's a difference between coercion and maybe, a strongly worded question. And some of these tipping points, are just come through trial and error. You have to document and record as best you possibly can. Interviewing is best done, if possible, with a digital recording. But you can also take your notes. If you're going to record, you have to generally get permission from the interviewee. Wiretapping is a very controversial, complex area. It's different in different states. So all of these things on this slide, and there's more to be concerned about. I'm just doing a few minutes of a short video to kind of give you some primary concerns, some basic concerns in terms of your ethical and professional duties when you're conducting an interview. Okay. Now, there's different kinds of interviews. You may be interviewing clients. You may be interviewing witnesses. You may be interviewing experts, maybe to determine if they're going to be viable experts to use in the litigation proceeding. But you can do intake interviews as a paralegal or a legal assistant or a non-lawyer. When the new client comes in, and so you have to ask them the appropriate questions, and maybe you'll have you'll have a pre-prepared list of questions, but this is just one kind of interview. Client interviews, intake, new client interviews, follow-up fact development interviews. You might be interviewing clients about a lot of different things. Once they've hired the lawyer, there may be 100 different new situations and new facts, and as the case is developing, that you have to find this information. And so, what you're trying to get from the interviewee is relevant material, pertinent, usable information. Okay. Trial preparation interviews. That's another huge part of what a paralegal or legal professional will do. You're assessing credibility and emotional state. Sometimes you're trying to determine if the interviewee is a potential witness, even if they're a client. You're trying to determine if they're of the right frame of mind, or you're trying to help them get in the right frame of mind. You wear a lot of hats as a legal professional, an attorney, a legal assistant, a paralegal. And so all of these are concerns and sometimes they intersect and overlap and conflate. The client interview can be all different kinds of interviews. Keep in mind, everyone, that interviewing is not just done by the attorneys. A lot of what the support staff does is, and that's quite ethical and that's quite fine, that's not considered practicing law per se. Interviewing witnesses or clients or whoever. It's assisting in the litigation process or whatever adversarial process it may be. It might be an administrative agency matter. It might be a ADR, alternative dispute resolution matter. Whatever it is, the interviewing process is important for the legal professional. Here are witness interviews. You've got fact witnesses versus expert witnesses. You've got friendly witnesses versus hostile. Hostile doesn't mean they want to fight you. It means that they may not be on your particular client's side. They give you information that tends to go against your client's legal position. It may end up being a witness you wouldn't want to call a direct witness at a trial. They may not want to talk to you. If you've had to subpoena them, that's different than someone that's willingly, voluntarily coming to want to speak. Eyewitness reliability concerns. If you're interviewing witnesses, you're trying to determine if they are reliable, if they have veracity, which means truthfulness, if what they can help with is relevant evidence and material evidence and credible evidence, what their memories are like, what their veracity is like. Would they be a good witness? Or, there could be a lot of things that could undermine their credibility. You're trying to determine all of these factors. Memory contamination risks. A lot of things are beyond the control of the interviewer. The length of time it takes to get a case into an actual trial sometimes. Time lapses. Times go by where you can't control certain things, but you can control the interview as best you can. But interviewing witnesses is oftentimes very different than interviewing clients, okay? They can overlap. Your client may also be their own best witness too. But whether you've got an expert witness or a fact witness, as I said earlier, you're going to want to probably write down a list of the questions that you intend to ask. You're not probably going to want to wing it. But be prepared. Another thing, I sound like a Boy Scout or a Girl Scout, but before you conduct interviews, you have to be prepared. And so all of these information on these slides about the kinds of interviews, you'll know beforehand, before you start your interview, what kind of an interview it's going to be. Okay? So you can best prepare that way. In a legal setting, it seems to be best, from my experience over the years as a practicing lawyer, to have a structured interview. Have the questions already on a checklist for yourself. Have a willing, friendly witness or client. Have it structured. If it's not structured or it's flexible, or it's exploratory, then it sometimes is just good to let the interviewee just talk. But this is also when it's best to have the interview recorded so you don't miss anything. Because if you don't know what they're going to say, then you're going to have to review the transcript later and cherry pick out of it what the important, relevant evidence or information is. But again, this you'll know before the interview. Is it a structured one, or is it someone you've maybe come upon? Maybe you're visiting the scene of an accident or something, or you're also a witness and you want to get immediate information, or it's a last minute interview, or you haven't had time to prepare your set list of questions. But a structured versus an unstructured interview is important to know the difference. Here is, to wrap this up, here's a list of things to help you prepare. Okay? Before the interview, during the interview, and after the interview. So, I won't go through every one of these, but, you want to be able to review all the information you need, whether it be the pleadings, the police reports, the contracts, the discovery materials, the employment contract, whatever kind of a lawsuit it is. Is it a probate case? Is it a workers' compensation case? Is it a criminal or a civil matter? You'll know before you take out on this interview exactly the kind and type of interview it will be. So you'll be able to hopefully access all the information, tactile information that you have needed before the interview. Develop your objectives, prepare your questions. And by the way, open-ended questions are always best. Don't provide yes or no questions, because all you'll get back is a yes or no answer. You want to get more than that. Unless you just want a yes or no answer. But, open-ended questions, be very diplomatic about the way you approach sensitive topics, use your interpersonal skills, plan the interview, the chronology of it, the theme of it. You'll go from point A to point B, and then during the interview, establishing your rapport, your active listening, your nonverbal cues, all of those things under the during the interview part of that slide have to do with interpersonal skills. And the only way to be a good interviewer is to interview. And you get better with practice, okay? And then to wrap this up, after the interview, document everything, get your notes all preserved, get your transcript printed out, cross all your T's and dot all your I's, and then identify what information follow-up you will need. Now, I'm going to wrap this up with, you will study interviewing processes and techniques in other coursework. Having to do with civil litigation or criminal law, or maybe a separate course called interviewing and investigation. But you'll need to know all of these tools and be able to use them when you do the process of interviewing. And I just wanted to kind of give you a little very quick cursory checklist of things to think about when you're out there as a legal professional conducting interviews. Okay, so thank you.